most notably Dr. Minchola's report that there is clear and convincing evidence that he cannot be restored to competency. So laying out my thoughts, Mr. Taylor, what's the defense's position on this?
In light of the court's findings and beliefs in that regard, I think that's probably the way we, it's unfortunate that the neuropsych would not provide an opinion as to restorability.
She felt, I mean,
dismayed. I read it, but I mean, I was dismayed about that, but had that, being that as it may, I think that the court is on the right path, and given our choices and given what I think the court is going to do anyway, I would so stipulate out of custody restoration.
okay, Mr. Roach, he needs to be heard on that point.
Judge, normally I would not. In this case, it's been reported to me that Mr. Noriega, up to fairly recently, was still giving lengthy sermons at his church, which seems to me to be directly in contradiction to him being incompetent. What I've not been able to do is to identify anyone who could come and testify to that. And Judge, I wouldn't ask to set a hearing right now, but could I ask, again, if we reset it for a week, Mr. Noriega does not have to be here. That'll give me the opportunity to see if I can actually document if that is true, because I think that would change things if that was actually happening. And I just have not been able to find a witness.
Judge, the standards, of course, competence, to stand trial and or assist attorney in defense, not to provide a sermon.
Well, I agree. I understand what the legal standard is. I think Mr. Roach does too. But there is frequently the case, not just in this case, but in general, where collateral materials can be potentially illuminating to either restoration staff or to evaluating doctors as to whether or not someone is or is not competent. So, and I am confident that the restoration team would be interested in having those materials if, in fact, they can be procured. I would imagine that may be of note to them, potentially. So Mr. Roach, I guess so you're asking for a one-week continuance, and so with that, I would be inclined to not grant continuance unless the state is considering challenging the reports as they currently stand. If the state is acquiescing to the placement into out-of-custody restoration but believes that there may be additional information that could be worthwhile for the restoration team to consider, then I'm inclined to make orders consistent with having him placed into out-of-custody restoration today, and of course grant the state leave to provide any collateral it seeks to provide to the clinical coordinator, who can then provide it to the restoration team. So, Mr. Roach, what is the state's specific position on that issue?
Judge, given the consistency of all three evaluators, we have no objection to putting them in the program, and then I will attempt to gather more information that would be provided if necessary.
All righty. Mr. Taylor, anything further before I make findings?
No, I know what the court's findings will be, so I will request that my client I be permitted to waive my client's appearance throughout the pendency of the out-of-custody RTC proceedings until such time as he actually gets into the program. As we know, it's quite some time of a wait, so I don't want him to have to keep coming in here for continuances, please.
I'm not going to provide a blanket waiver of his need to come to court, but I will excuse him from the next review hearing date that I set, because that's the same courtesy that I afford to other defendants that are on the wait list. I've done that with other gentlemen that have been seen this morning so far. So he can basically sit out July 27th, and then I'm happy to hear you out on whether or not I ought to continue that approach thereafter. So let me make some findings. Counsel, having stipulated the court determining competency based upon the written reports pursuant to Rule 11.5A, having considered those reports, the court finds the defendant is unable to understand the nature of the proceedings and or is unable to assist in his defense, and is therefore incompetent pursuant to US 134510. Court further finds that there's a substantial probability that the defendant can be restored to competency within the time frame permitted under Arizona law. Therefore, it is ordered committing the defendant to out-of-custody Pima County Restoration and Competency Program. It's further ordered setting a review hearing. That's going to be on Monday, July 27th, 9 o'clock in the morning in Division Hall F to see where things are at. So, Mr. Noriega, I'm not sure if you're able to hear me or how well you're following along. But
He's not.
Okay. Well, Mr. Taylor can let you know what all happened today. set another hearing for you about 3 months from now. So Mr. Taylor, I'm sure can take some time and explain all of this to you, okay? Thank you. Anything further?
No, sir.